Hi, everybody. Thanks very much for joining us today. Welcome to our series 2 of our Good Work Plan webinars. So today's session is going to be focused around the area of reform called Clarity for Employers and Workers. So for those of you who have not spoke to you before, so my name's Sophie. I'm one of the senior HR advisors in the Code Total HR team. So day to day, predominantly we're on the HR helpline, supporting members with any HR cases or queries they may have. And I also provide bespoke support to our Code Total HR members in terms of contract support, maybe letter writing, bespoke policies for them as well as sort of advice and support with any HR cases they may have. So let's have a look at our aims and objectives for today's session. Our aim is to increase our understanding of the changes to employment law that the Good Work Plan will introduce. And as I've mentioned, today we're going to have a focus on the clarity for employers and workers. Our objectives from today's session: number 1 is to discuss an overview of employee rights relating to the Good Work Plan. We're going to highlight the risks of failing to follow employment law. And we're going to explore how the Code Total HR service provides you with essential policies and template letters to really help you comply with your legal obligations. So our learning outcomes from today's session: we want to, number 1, improve our understanding of the changes that will be brought into effect with the Good Work Plan. We want to understand the statutory employment rights. And we're going to look at how we can avoid potentially costly mistakes relating to employment law. So our session content, just to give you a bit of an overview of what we're going to be focusing on today. The first area is the Good Work Plan overview. So for those of you who have missed webinar 1, we're just going to give you a bit of an overview of what the Good Work Plan is, just to kind of set the scene for you. We're then going to look at the area of reform called Clarity for Employers and Workers. And this includes some various different topics. The first one being employment status. The second is the written statement of particulars. We're going to have a focus on the updated rights for agency workers. And also we're going to have a look at the changes to holiday pay. We're going to end the session with a how to prepare. And there'll also be time for some questions at the end. So first of all, for those of you who have missed our episode 1 in our series of 3 webinars, we just wanted to give you a quick review of what the Good Work Plan is. Just quickly, for those of you who have missed series 1, it's now available on the Code UK website. So if you haven't watched that one, just recommend you go and have a look at that. So back in 2016, the government at the time commissioned a gentleman called Matthew Taylor to undertake a review of modern working practices. Matthew Taylor completed the review in 2017. The government considered the review and published their response in 2018. As part of the Taylor review and the review of the modern working practices, Matthew Taylor identified the need for 53 changes to employment law. The government's response has accepted 51 of those changes. Now, not all of the changes are going to come into effect from this April, but the majority will be. There are a few changes that came into effect in 2019. And again, if you want to find out more about those changes, please have a look at episode 1 in our series. So I have mentioned that there are a couple areas of reform under the Good Work Plan. So because there are so many changes, so 51 in total, they have been grouped into more manageable chunks for you. The first area is with regards to fair and decent work for all. The Fair and Decent Work webinar is on our website, as I've mentioned, but it really has a look at things like the right to request a more stable contract is a key one in there. Today's session is going to be focused on the clarity. And the webinar that will be with you on the 5th of March is going to be around fairer enforcement. So that will include things like the updates to employment tribunals. So there's going to be naming and shaming and some penalty notices. So let's start today's session by having a look at employment status. So your employment status really determines the rights and responsibilities you have within the workplace. It's not just determined by the contract that you're issuing your team members, it's actually really determined by a set of characteristics and how you treat that team member in practice. There are two different frameworks in the UK which determine your employment status. The first one is for the reasons of taxation. So the first one will identify whether or not you're an employee or a self-employed person. Now, self-employed team members are responsible for paying their own tax and national insurance contributions, whereas your employees will be added to your payroll. You will make those deductions and you will also be required to pay the national insurance contributions for the employer. The other framework is with regards to employment rights. So the framework for employment rights is actually a three-tier approach, and you have the status of an employee, the status of a worker, and the status of a self-employed team member. And this is really used to determine what employment rights you have within the working relationship. In the next couple of slides, we're going to have a look and determine the characteristics in each of those statuses for you. Just want to quickly touch on a phrase that you've probably heard quite a lot over the last couple of years, and that's that of the gig economy. Now, the gig economy is a phrase that's used to determine the flexible, sort of short-term, more casual approach to the working relationship. It's come about and actually doubled in size in the last couple of years. So back in 2016, it actually made up 5% of the UK working adult workforce, whereas more recently, that has actually increased to 10%. So I think this is one of the key reasons as to why the government decided it was the right time to have a review of modern working practices. So an employee status. An employee would be working under an employment contract, and they would be required to carry out that work personally themselves. So they wouldn't have the right to provide somebody if they weren't able to work. The employer will have control over the circumstances of that work. So that's things like the place of work, it could be the hours of work and the role that that person's carrying out. And there's also a mutual obligation. So the employer is obligated to provide the hours of work and the employee is obligated to turn up and work for that employer. Having employee status means that you're entitled to full employment rights. Worker status is probably one of the most difficult ones to identify because it's kind of in between your employee and your self-employed person. Worker status again means that they have to personally carry out the work, so they don't have the right to send a substitute. However, this time there's no obligation on either side. So the employer isn't obligated to provide hours of work, just as much as the worker isn't necessarily obligated to accept that work. A worker status accrues sort of limited employment rights, so that includes things like the right to national minimum wage and living wage, and also the right to some paid time off, such as maternity leave and paternity leave. Your worker status will usually be found under your more 0 hours or casual contracts. And the third status that we're going to look at is that of a self-employed team member. Self-employed individuals work under a contract to provide services. And under that contract, they have the right to provide a substitute. So that means that they don't have to carry out that work personally. So if you're thinking of this in a practice environment, this is the right to provide you with a locum. They also will be liable for paying their own tax and national insurance contributions, and they will probably be invoicing you for their time. A self-employed person has no employment rights. However, they are protected under both the Health and Safety Act and the Equality Act, so they're protected from being treated unfairly. We can't really speak about employment status without touching on IR35. So for those of you who aren't aware of IR35, it's a piece of legislation that came into effect in the UK back in the year 2000. And it's really in place to help crack down, and sort of the main objective is to reduce and eliminate any fraudulent tax avoidance. Now in 2020, so April this year, medium and large businesses are going to be affected by some reforms. The reforms are going to be that the responsibility will shift, and the responsibility at the moment is with that of the self-employed team member. So they will determine what their tax status is. Whereas with effect from April, this will actually shift, and it will be the responsibility of those businesses to advise on their tax status. There's also going to be some added responsibility to agencies that are providing self-employed team members. They will have the responsibility to advise what status they should be sort of taken on with. It's therefore really important that we look quite carefully at the self-employed agreements that you have in place with your team members. That leads us on nicely to some case law that we want to quickly talk to you about. So in recent times, courts and tribunals have really been determining both the tests for self-employment and employment status, as well as the characteristics that make up each of those statuses. We have seen from 2011, I think was the turning point really, in the Autocleanse versus Belcher case, where the courts and the tribunal were more open to looking far beyond that of the contract that was given to that team member. They are now looking and more open to looking at the working relationship, so how that team member is treated in reality. Now, we've really seen that in most recent times with the Uber and Pimlico Plumbers cases. So they are both at the moment looking to win the worker status. So the team members there have took these businesses to court and to an employment tribunal to try and fight for worker status rather than being self-employed. On winning and sort of accepting that worker status, they will also be entitled to the associated employment rights. So that's why it's so prevalent at the moment. It's very much that of the gig economy, sort of with these new and emerging workforces, that this has all sort of come about. So what exactly will the Good Work Plan be doing about this, and how is it going to tackle it? Well, Matthew Taylor identified that in order to really sort of establish the status, the employment status, there needs to be some reforms that will be sort of considered by the government. So Matthew Taylor has proposed no less than 8 recommendations that involve the employment status. We've picked out the top 3 for you. So the first one is that the government has accepted that they will make they will align the employment status frameworks. So this is what we were talking about earlier in terms of your tax framework and your employment rights framework. So the government are going to look at those and do all that they can to try and reduce any differences that they may have. The government have also accepted that more support needs to be given to both individuals and businesses with regards to understanding their rights and tax obligations. And also the fact that the status tests are going to place a lot more emphasis on the control in that working relationship rather than the contracts or the sort of the right to send a substitute. So it's really important that you keep an eye on these reforms, have them on your radar, because it's things that could certainly affect your businesses. Now, in preparation for these reforms coming into place, the first recommendation is that you have a read of the IR35 article. So our solicitors Rudlings and Wakelam have provided an article to us, and that will be with you in the next few weeks. It will be published on the Code UK website, and that will really help you to understand what your rights and obligations are with regards to the updates. I'd also recommend that you start to assess your contracts. So this is with regards to your employed team members, your workers, as well as your self-employed team. So understanding that they're on the right contract will help you in practice to treat them in the right way. There's also a HMRC have a test really that you can do online to check your employment status for tax. So if you're unsure what your sort of team members should be on, then do sort of share that. And finally, if you have accountants or sort of financial advice available, we'd recommend you have a chat to them about what IR35 could mean for you in your practice. So the second area of reform that we're going to focus on is with regards to some updates to the written statement of particulars. Now, just to sort of let you know, a written statement of particulars is the basic information that you need within your employment contracts. So the first recommendation that's been accepted by the government is that there will be an extension to the right for workers. So the government has accepted that workers should be entitled to a written statement of particulars just as much as your employed team members are. There's therefore going to be an amendment to Part 1 of the Employment Rights Act that documents this. And this will be effective from this April, that you must ensure that you're providing your workers as well as your employed team members with the written statement of particulars. The second area is with regards to the right to clarity. And again, under Recommendation 6, Matthew Taylor has identified that in order for the written statement of particulars to be sort of useful and to be able to provide your team members with the information that they can make really informed choices, that statement of particulars needs to be available to them on day one. So at the moment, that right is within the first 2 months. So that's something very much to keep on your radar and something to really get into the habit of doing now if you can. In addition to those two reforms, there's also going to be an extension, and the extension to the mandatory information that's included within a written statement of particulars. Now, just to let you know, any sort of iComply members, Total HR members in the room today, our staff terms and conditions of employment do already include all of the details within this extension to the mandatory information. However, our solicitors are currently reviewing our contracts, and if they do recommend any updates, we will of course let you know. So additional mandatory information. If you're taking on team members who will be on a fixed term contract of employment, so this could be to cover for a period of maternity leave, then you need to ensure that you include the job duration. So this is the start and predicted end date. You will also need to include the work pattern. So this is the hours per week as well as the days that they will be working. A full remuneration package is also required. So this isn't just the hourly rate or the salary that team member will be entitled to, but any monetary benefits that you provide your team members with should now be documented within the written statement of particulars. Notice period requirements. So there are already statutory provisions for notice periods. If you're unsure of those, please sort of do check and give us a call on the helpline if you need some advice there. But the notice period requirements now also need to be clearly documented and evidenced within the written statement of particulars. Eligibility for sick leave and pay, and eligibility for other types of paid leave. So other types of paid leave could be maternity, for example, or paternity leave, shared paternity leave as well. So this needs to be clearly documented within the written statement of particulars. And lastly, if you have probation periods for new team members, this also needs to be very clearly documented within the written statement of particulars. And it's actually very important that it is in there because a probation period doesn't actually have any legal standing. So it's important to have that in there, as well as the duration of that probation period and any, what you would expect from that team member during that time. So in preparation for this area of reform, we really recommend that you are providing all of your team members, both your workers and employees, with the written statements of particulars, and that you get into the habit of doing this on either day one of employment or even better, prior to day one if you can. And also just have a check to ensure that all those mandatory requirements are covered in your current written statements of particulars. Now, the next area that we're going to just really quickly touch on is that of the additional rights for agency workers. Now, this one I'm not going to go into too much detail with because it's actually going to be the responsibility of the employment business. So that means the responsibility of the agency to provide this, but it is one to definitely be aware of. So Matthew Taylor has really identified under recommendation 11 that something needs to be done to address the transparency and to address the clarity really for agency team members. Now, it's going to be the responsibility of the agency to provide that team member with a key facts page. The key facts page must document the type of contract they're working under, the rate of pay that they'll receive, any deductions that could be made, as well as an estimate on what that would look like for their final take-home pay. So the last area that we're going to focus on is with regards to holiday pay awareness. So as part of the Good Work Plan and as part of this area of reform, Matthew Taylor has really identified that there does need to be greater transparency in terms of holiday pay. There also needs to be a better sort of awareness of that pay entitlement, and the government have therefore accepted and will look at doing a campaign that will boost awareness and understanding. And that boost of awareness and understanding is going to be for both employers and employees and workers. Another sort of recommendation that was accepted under number 10 is the fact that the current holiday pay reference is really limiting team members from taking full holiday pay. So it's particularly affecting sort of seasonal workers. The government have accepted this. They agree, and what they're going to do is actually bring forward legislation that will increase the pay reference period from the current 12 weeks to 52 weeks. So the pay reference period determines the average week's pay. There's also going to be an updated and improved holiday entitlement calculator. Now, we had a lot of calls on the helpline when this was removed from the gov.uk website, but just to let you all know, it was only sort of taken away for some updates and improvements in line with the Good Work Plan recommendations, and that one is now live again for you to use. The government have also alluded to the fact that they might potentially look at doing a pay calculator as well, so a holiday pay calculator, because this will really improve the employer's understanding of what exactly they need to pay in terms of time off for team members. That is something that hasn't completely been accepted, but it is something that they have on their radar, but there's no timescales there yet. So in preparation for this area of reform, it's ensuring that you spread awareness. So ensuring that your sort of accountants, your management team, they're all aware of the holiday pay entitlements, and that you're checking that you're using the right reference periods. So effective from April, you're using the 52-week reference period rather than the 12-week. And obviously, if you are unsure, then do, please get some expert advice, if you do have any questions there. So coming to the end of the sort of areas of reform that we want to make you aware of is just really highlighting the risks of failing to follow these updates to employment law and employment law as a whole. So the first one, and probably the most obvious one, is with regards to employment tribunals or ACAS early conciliation. Now, if you are failing to follow employment law legislation and your team members feel aggrieved by this, they are more than likely going to go to ACAS to make that claim. Before it would ever get to an employment tribunal, ACAS early conciliators will give you a call to let you know exactly what the claim has been and who's made that claim. They will be looking at working together with you to come to a sort of a mutual agreement to prevent it coming to an employment tribunal. 99% of the time, that agreement and that mutual sort of end to the matter is going to be a financial one. So there's a big financial risk here if you do end up in that situation. As well as the fact that your team members could be raising grievances. So a grievance is raised if a team member feels that you're potentially not treating them fairly, not following employment law legislation. They will raise that grievance to you. It takes quite a lot of time to deal with a grievance within the workplace. I think the HR team will probably agree with me in terms of probably on average you're looking at between 12 to 16 hours to deal with a grievance from a team member. So that's a lot of time, a lot of energy, and it's quite draining and quite a stressful time period. Grievances are going to have a really sort of big knock-on impact to the atmosphere and morale of your team. So if you've got a team that are constantly raising grievances to you, it's really going to affect how they're sort of it's really going to affect their working relationship with you. Poor morale and atmosphere will be picked up on by your patients. They are more than likely to sort of pick up on the fact that your team members aren't sort of happy in the workplace, and that can have a detrimental impact on your reputation. So your patients will be picking up on this, but also your reputation as an employer. So, we all know that team members talk and speak sort of outside of the workplace. So just think about how this affects your reputation. Also, when you come to recruit next time as well, having a tainted or a tarnished reputation can really have a detrimental impact on you. So I just want to make you aware of some key policies and templates that we have available to our iComply members and our Total HR members. So we have some employment contracts templates that you can use in terms of our staff terms and conditions. And then the one for your 0 hours team, your more casual team members, it's the 0 hours staff terms and conditions of employment. We do have a guidance document as well that will help and support you with identifying which is the right contract and help you with some clause definitions. And I've also got on screen for you the most popular sort of self-employed agreement templates that we have on iComply. So we've got the provider performer agreement and your associate agreement for a private practice, as well as a couple of hygiene therapist agreements. And these are our all for self-employed team members. There's also a guidance document that will again help you to identify the contract, as well as maybe any clause definitions you're struggling with. Our Code Total HR members, please do give us a call if you're unsure of the right contract to use, and we can support you and provide you with some bespoke support there. So some immediate actions to consider following today's session. I suppose the first one and the most obvious one is to really assess your workforce status. So understand exactly what your team members' status is within the workplace, and that will help you with how you sort of treat them and that working relationship. So it's about getting the contracts right as well as how you're treating them. The second is to review your team members' contracts. So ensure that they're on the right contracts, but also that you have everything with regards to the extension to the written statement of particulars. So do you have everything covered in that contract? And are you providing it to workers as well as employees? Review your policies and procedures. So just make sure that they're good work plan ready. So our iComply and Total HR members, if there are policies or procedures that need updating, you will be alerted to this. And provide training to your management team. So ensure that your team understand what the changes are, how it's going to affect them, and therefore how they treat their team members. And then spread awareness where you can as well. So I'm not saying you should sort of have a meeting where you inform your team members of all 51 changes of the, included in the work plan, but it's a good idea to sort of spread awareness and ensure that your team members know that you're on top of things. That will really help with the morale and the atmosphere in the practice. And also seek expert HR advice if you're ever unsure. So big changes in employment law is why we have the Code Total HR and Employment Law Service. So the service can really support you with the setup of your staff handbook and the contracts for your practice. You'll undertake an annual contract and HR documentation audit, as well as having access to a HR web application. The application will really help you to manage your team members in terms of sort of holiday, sickness, training and performance, and it will also enable you to store those HR documentation as well. In addition, you'll get access to a Code HR advisor who will be able to support you with any cases you may have, as well as any editing support you may need. If you would like to find out more about the Code Total HR and Employment Law Service, please do give our team a call or email the email address on screen now. Or if you'd like to, you can visit codeuk.com /HR-demo, and you can book a demonstration of that web application. And just quickly, some up-and-coming events that we'd like to make you aware of. Number 1 is the Good Work Plan, webinar part 3, and that's with regards to fairer enforcement. So that's the third area of reform under the Good Work Plan, and that's with you on the 5th of March. The link will be available sort of further to today's session, so you can go and book your space on that webinar. That webinar will also include some further employment law updates to make you aware of. We're also going to be in attendance at the Digital Dentistry Show, and that's in London on the 7th of March, as well as the Mental Health in the Workplace Conference. So that will be again in London on the 10th of March. And we're also sort of hot off the press, we're going to be doing a Total HR workshop. That's going to be at the Amber Hotel in London on the 5th of June 2020. So June this year. We're really excited. The team are really excited about holding another one of these workshops. Tickets aren't available just yet, but do keep an eye on the website if you would like some further information. As always, you can watch any of our previous webinars by following the link on screen. And I'd really recommend having a watch of the Good Work Plan webinar part 1.